Wrap up 2024 with a solution that helps you do more with less. Unwrap case management tools built for personal injury firms. With features like automated calendar reminders and all-in-one document management, CasePeer keeps your cases on track from start to finish. Unwrap the gift of CasePeer by December 31st and get a $250 gift card. Terms and conditions apply. Claim offer at www.casepeer.com.
Welcome to Brief Encounters and another episode of the Securities Regulation and Enforcement series. My name is Valerie Mirko. I'm a partner at Armstrong, Teasdale, as well as the leader of the firm's Securities Regulation and Litigation practice. And with me is my series co-host, William Nelson. William, can you go ahead and introduce yourself?
Yeah, William Nelson. I'm the Director of Public Policy and Associate General Counsel at the Investment Advisor Association. And yeah, just really excited that we're, coming to the end of our first season of this wonderful podcast, Valerie.
That's right. We started this in the spring of 2024, and we're recording just about mid-December of 2024. And this is really the end of our first season. We have a lot to talk about, including who the new SEC chair is very likely to be. And then after we've discussed the nominee, let's look back on 2024 in our first season and looking ahead to 2025. So, William, what can you tell us about Paul Atkins?
Yeah, so I think, from everything I've seen, it has been a well-received nomination. Again, he is just the chair-elect. There is still a Senate confirmation process, but, this is Paul Atkins. I think the firm he's currently at is Potomac Global Partners, but previously at the SEC, previously served, I believe it was from 2002 to 2008. So again, really knows the agency and everything we've heard from both prior and current SEC staff, very well respected. I think for a lot of us in this industry, he's, what I would call an institutionalist, well regarded. It'll be interesting to see what his policy priorities are, but at least from the outset, I think there has been a lot of comfort in knowing that someone who has that gravitas and experience is going to be leading the agency into 2025 and beyond.
I think that's exactly right. And in addition to the fact that Paul Atkins was a commissioner for several years, about 15, 20 years ago, he was also staff to two former chairs back in the 90s. So this is really his third time on the 10th floor, so to speak, in terms of being part of either SEC leadership or counseling SEC leadership. So I completely agree that he is an institutionalist and he's somebody who has deep knowledge of the SEC and how it has evolved over several decades.
Yeah, absolutely. And I think that, going forward, although we don't know yet, again, it's, going to be the President-elect Trump's priorities as well. But we know, I think, just from, some of the public reporting and some conversations we've had, I think there is going to be a real refocus on capital formation, especially with small businesses raising capital, a real focus on cryptocurrency and digital assets, providing guidance and certainty in that area. I believe Paul Atkins currently serves as chair of the Token Alliance. He's been very outspoken on the issue of cryptocurrencies and digital assets. Also, I think we're going to see a lighter touch related to enforcement. Again, doesn't mean we're not going to see enforcement, but I think there is going to be much more of a focus on investor harm, intent. I think going away from, some of these, maybe we can call them more technical violations that we've seen over the past few years at the commission.
I think that's exactly right. And, as somebody my practice is largely SEC enforcement defense, I always find it very interesting when there's a change in administration, because to your point, it doesn't necessarily mean less enforcement. I think there will still be vigorous enforcement in matters of investor harm. But what I do not think we will see as much is enforcement orders instituting proceedings that have no civil penalty. and actually had no harm and were more technical violations. Frankly, I'm really hopeful the SEC goes back to doing 21A reports when they want to message to the industry an important change after an enforcement investigation, as opposed to using the enforcement investigation and the order instituting proceedings. Because I just don't think it's fair, whether it is to investment advisors or broker-dealer registrants or public companies or private companies, to end up with an SEC order that is really about a technical violation or something where there was no investor harm, there's no civil penalty, yet they still have that disclosure burden, which is what we've seen in the last 4 years. And I'm really hoping that trend ends. And as we move now to an SEC chaired by Paul Atkins, that we see a more judicious application of enforcement with a focus on investor harm as opposed to these messaging cases, which I just don't think are fair to the industry.
Yeah, no, and I think, Valerie, that's absolutely right. And even in addition to the enforcement focus, I think there is a lot of optimism around the exam function as well. I think historically we have looked at the SEC, being a former chief compliance officer for a registered investment advisor, we really look at the SEC as a partner, and we really want them to view, compliance officers as the first line of defense and partner with them. And, again, really looking at the reasonableness of your compliance program. And, I know, Valerie, you're going to talk a little bit about some of these recent cybersecurity cases where, for some of these cases, it actually ends up being the victim of, some type of data breach or ransomware hack actually becomes the victim again of SEC enforcement action.
I think that's exactly right. And it is deeply unfair. And I'm hoping we move away from this trend. So one of the things, William, that you and I discussed as we were preparing for today's episode that we think will not change, emphasis on not change, is the SEC's concern regarding cybersecurity and data privacy more generally and protection of client and customer information. And I say that because, of course, there's been several pending rules that touch this area that were proposed during the Gensler term and that none of us think will finish. There's an IA cybersecurity rule, there's an IC cybersecurity rule, there's also a vendor management component. There's lots of different ways in which cyber and data privacy could sort of be touched through those rules. And I don't think those rules will move forward because we're really getting very close to the end of the term. But what I do think will continue is the SEC's focus both at the exams level for the firms that the SEC does examine, and then more broadly at the enforcement level for all firms over which the SEC can have jurisdiction regarding cybersecurity. So, what does that mean? Obviously, there can be Reg SP settlements. Obviously, there can be, things like Reg SID could figure into settlements. But I think the staff is getting increasingly creative with how to apply the existing federal securities laws and rules in cyber-related events. And what we saw most recently, it was on December 2nd or so that the order came out, if anyone wants to look it up, but it's a broker-dealer that had a ransomware attack, and no one could access the broker-dealer's records for 3 or 4 months. And that has become, in the SEC's eyes, a record-keeping violation. I disagree with the fact that it resulted in an order instituting proceedings, even though there was no civil penalty, because to your point, William, the firm is as much a victim. But I do think it's important as a takeaway to see that the staff is willing to look, again, throughout the federal securities laws and regulations for hooks, which involve cyber, ransomware, data privacy, and so forth. And I think that trend will continue. And that order to me is a messaging order. Now, of course, the obvious next question is, well, but it's the end of the Gensler era. Will that type of scrutiny continue or that type of case theory continue? I do think scrutiny and concern around all things cyber, data privacy, protection of client information, protection of firm information, that concern will continue. I do think that case theory of using the record keeping rule is novel, but I could see that occurring again in sort of the next SEC, once Paul Atkins is confirmed as chair. I don't think that case theory is going away. And what often happens is you'll see a case theory in one part, you'll see a case theory with broker dealers eventually get extended on to investment advisors. So that's where my concern lies, in that this could be extended. And I don't think that case theory is going away. The other thing I will note is I also assist clients with exams, both SEC and FINRA exams, and especially SEC exams. And I've seen yet another renewed scrutiny on registrants' cybersecurity practices, record-keeping practices, data protection practices, technology and vendor management practices. So this is continuing to be an area of concern for SEC exams, very much so. We're seeing it also on the FINRA front. But sticking to the SEC, the exam staff is very focused on this issue, which tells me the enforcement staff will also continue to be focused on this issue.
Yeah, no, and I think that's absolutely right, Valerie. And along those lines, I think that in addition to, a little bit different focus on cryptocurrency and digital assets, I think there will be a renewed focus on emerging technologies like artificial intelligence, but, also the opportunities they present, maybe rather than just the risks they present. So again, that really does line up with cybersecurity, data privacy, and this whole new world we're in. How do you keep up with those types of technologies? So I think that is going to be a big concern of the SEC. But unlike the predictive data analytics rule, which was proposed and will likely be not moving forward in the new administration, but I think we will see focus specifically on emerging technologies like artificial intelligence and how advisors and firms are using those technologies, either client facing or in their back office, such as compliance or business practices.
I think that's exactly right. And the thing that I really want our listeners to remember is disclosure remains paramount, especially, like, again, I work mostly with investment advisors and broker dealers. So let's use that as an example. We've seen enforcement actions in the last few months that are really just greenwashing through disclosure. And that's what the order is getting at. We're starting to see that with AI. I think what happens with portfolio managers is they want to use, whether it was ESG or AI as part of their marketing, but they need to be able to substantiate it and it needs to be disclosed accurately. I do think we're going to keep seeing that, especially for AI, because to your point, there's a lot of opportunities. It's what the market's interested in. It's what the industry's interested in. But, on the portfolio manager front, it needs to be disclosed accurately. And I do think that's a case theory that will continue in terms of any kind of scrutiny around firms using AI. Now, that's different, of course, from looking at AI opportunities. I think what was really worrisome about the PDA proposal was that it really hampered innovation. And I do believe that proposal, to your point, William, I think you're exactly right. I think that proposal is not going anywhere. And I think there will generally be sort of more of an acceptance by this new SEC as to both the benefits and the risks of AI, but emphasis on the benefits. That said, disclosure still needs to be balanced and so forth. And that's just something to bear in mind, of course.
Yeah, absolutely. And I think too, looking forward to these first couple months of the administration, we recently heard that Commissioner Lizarga is also leaving the commission along with Chair Gensler, much more before the end of his term. I think his actual term runs through 2027. His wife, I know, is having some health issues, so I hope she's okay. But what that does leave after January 20th is a 3-person commission. And what that means from either enforcement, rulemaking, or any action by the agency, you need 3 commissioners for quorum. So theoretically, that means that, you can have a 2-to-1 Republican with Commissioner Peirce, Commissioner Ueda, and then the sole remaining Democratic Commissioner Caroline Crenshaw. But if Commissioner Crenshaw decides not to participate, you couldn't do anything because, again, you wouldn't have that 3-commissioner quorum. So it could be really interesting over these first couple of months of the new administration before, we know these nominations and appointments take time. So for the first couple of months, I think after January 20th, when Chair Gensler and Commissioner Lizarga both leave the agency, it'll be very interesting to see what gets done in those first couple of months.
I think that's exactly right. And I do think there's been some planning ahead for that. So, obviously my area is enforcement and exams. We're seeing a lot of enforcement investigations wrap up. We're seeing a good number of orders still coming out. We did see the push towards the end of the fiscal year, but the momentum has continued, and I think will continue through the end of this year and even perhaps into very early in January. On the exam front, the exam priorities are very middle of the road, very back to basics, focusing on protecting client and customer funds, mitigating the potential for investor harm, robustness of compliance programs, whether it's an investment advisor, broker dealer, transfer agent, and so forth. So, you see the preparation across those two divisions for the transition, i.e., getting things wrapped up with the enforcement division, but then for the exams division, having a set of priorities that allows them to keep working despite the transition. So we're seeing that there. The rulemaking parts of the SEC this is a time where there are much more pencils down, where they're taking a look at sort of more broadly, where are they getting a lot of questions in the last few months, but they're waiting for their next set of priorities. As we discussed on our last episode with Sarah Krovitz from Stradley, she really emphasized that the 3 pieces of the SEC's mission, protecting investors, capital formation, and market efficiency, those do not change. So no matter who the administration is headed by, those are the mission pieces. It's more which of those pieces is emphasized that evolves and changes depending on who's in power. And I thought Sarah said that really well. And that's exactly what we're already seeing. Enforcement is wrapping up a lot of matters. They still have investigations. They always have investigations. Exams has a set of priorities that they can keep working under. Rulemaking is a little more pencils down, whether in TM or IM or Corp Fin, because that's really where they're waiting for the priorities. But the reality is, I think the business of the commission continues despite the transition. It might be some of the larger decisions and things that require commission approval that slow down during the transition period.
Yeah, and I think that's right. And I think it's also interesting, now that we are wrapping up this first season, just kind of looking back, I think one of the things that really stood out for me in 2024 was just really the SEC's authority. And what I mean by that is, we saw the Supreme Court decisions come out. The courts are not going to give that kind of deference anymore to the agencies in their rulemaking. We've also seen lower courts, both district and appellate courts, really chipping away at the SEC's authority for different rulemakings. The private fund advisor rule was vacated. We just recently had the SEC's dealer rule that was also vacated. So it's going to be really interesting to see, how this new administration next year and even, in the coming years really addresses how the courts have, at least in my mind, really kind of trimmed the SEC's authority. So it's going to be interesting, Valerie, to your point, with some of those different enforcement theories, it's going to be interesting to see what theories come out of the SEC in the coming years based on those court decisions.
I think that's exactly right. And then there's also the open question of, will targets of SEC investigations have more appetite to litigate in this current climate as opposed to settling, which, we're, to your point, we're seeing the courts really find against the SEC's authorities at seminal times, like the private funds advisor rule, for example. And I think that will also increase the appetite for respondents to consider litigation as opposed to settlement. That said, the idea of will SEC litigation increase has come up many times over the last 10 years. And while it's increased a little bit, there's still not been that accelerant factor that we've wondered could happen. I don't know if we're there yet either, but it is something to watch.
Absolutely. Well, all I can say, Valerie, is I'm excited to see what comes next. And our audience is just going to have to wait until our second season starting in January. But this has been, I think, a really exciting year, a lot going on. But no matter what, I think there's going to be a lot of activity that we'll be able to talk about and, bring some really terrific and interesting people on to talk about it.
I think that's exactly right, William. I think this was the right year for us to launch this podcast series. And I'm also very excited looking ahead to 2025 and the discussions we'll be having, whether it's just the two of us on some episodes, or I'm hoping we still get as many guests as we did this year. So with that, happy holidays to all of our listeners, and we'll see you for season 2 in 2025.
This episode of Brief Encounters was brought to you in part by our sponsor, CasePeer. Learn more about CasePeer in the description of this episode.